It's been 105 years since Texas held an impeachment trial for a statewide official. But on September 5th, Lieutenant Governor Dan Patrick swore in the Texas Senate, who served as the jury. He also swore in the officers of the court and attorneys for the defense and the prosecution. Using Sam Houston's historic Bible, he began what has been called the Texas Trial of the Century. After 90 days of preparation, Lieutenant Governor Patrick, serving as the trial judge, and the 31 senators who became the jurors heard over 60 hours of testimony regarding the 16 articles of impeachment that the Texas House sent over against Attorney General Ken Paxton. It became must-see TV across the state, and in the end, making history again, the Senate rejected all the articles of impeachment and acquitted Paxton. Texans are anxious to learn more about this historic trial. I'm Sherry Sylvester. Today I'm going to talk with Lieutenant Governor Dan Patrick and several of the senators who served as jurors in the impeachment trial for a behind-the-scenes look at what happened in those 9 days between the first gavel and the final vote. Lieutenant Governor Patrick, thanks for being here today. Let's start from the beginning. When did you first hear that the House might be impeaching Attorney General Paxton?
Very interesting. I had not heard from the Speaker in 2 years. No conversations at all. And out of nowhere, I get a text saying, "Can I come over and visit?" And I said, "Absolutely. Come on over." Well, the day before, someone had leaked information to me that the House might be impeaching Ken Paxton. I mean, that came out of the blue. I had no idea. No one was thinking about that. So after I had my conversation about property tax relief and school choice, I said to the Speaker before he left my office, I said, "By the way, are you all impeaching Ken Paxton?" And he said, "I don't know anything about it." And I'm thinking, well, you appointed the people on the committee doing the investigation. He said, "That's up to the investigation committee." So that's the first I heard of it and the first denial I heard of it. And of course, I look back on that. Either he wasn't telling me the truth, and I wouldn't accuse him of that, of course, but I would be surprised if they're going to impeach Ken Paxton and didn't tell the Speaker. And if they hadn't told him, then that meant the Speaker decided in about 72 hours for the first time in 100 years to impeach someone when he didn't have any evidence or any information or any record to go on. So either way, it wasn't a good answer from the Speaker.
And then what happened after that? Was there a press announcement? Did the articles of impeachment, were they delivered in the Senate by a messenger like they usually are? How did all that work?
So we have to remember this happened during the last week of session when we're in a sprint to pass important legislation. And so I was really focused on the legislation. I didn't have time to look at what they were doing over there on the impeachment. I just knew over the Memorial Day weekend, it came to the floor. The members didn't have much to go on to vote. They didn't have much time. I'm told they didn't know until a few days before they were even going to vote on impeachment. I was focused on passing property tax reform and other important legislation. And then once they did impeach him, I think it was 12 members, the House managers, the representatives came over and presented us the official articles. And that's when I suddenly realized that we're going to have to hit the books. We're going to have to study impeachment. It's nothing that I would have been prepared for. The last one was 100 years ago of a statewide official. We've only had two in the history of Texas statewide, one in the 1890s and 1917.
So what did you do first once you looked at 16 articles
Yes.
of impeachment? Not one, not two, but 16.
Yes.
Where did you go first? How did you wade through it?
And some of those 16 had 2 and 3 items in each one, so
Right.
It was more than 16. You might have said it's 30-some different charges or more. So the first thing I did was to get with my legal team, and we looked at the Constitution. And then I appointed a committee because we had to write rules. There are no rules. You know, it's called a political trial, which I called a political trial, but it can be more criminal. This one was more criminal or more civil. And I say it was more criminal by the way the House set it up and some of the jargon that was used, and also by the rules that were written. So I assigned Brian Birdwell to head up a committee with Joan Huffman, Pete Flores, Brandon Creighton, Phil King, Chuy Hinojosa, and Royce West. So a bipartisan committee of 7, some lawyers, some not, to begin to write the rules. And they spent an inordinate amount of time studying what happened in 1917, every other impeachment, in Texas, some statewide, some not, and around the country to find out what was the best path for us. And then after that, in a few weeks, we all gathered with all the senators and they discussed the rules. It was a long 2 days, really. Great debate, bipartisan debate of writing the rules. 31 rules, as I remember. Incidentally, 31 senators. Incidentally, 31 proverbs. It all worked out at 31 for some reason. And they passed 25-3. And that was the beginning of then 3 months during the summer of tremendous work. And during that time, as judge, and I had the powers of a district court judge, I could put someone in jail for contempt or fine them. I mean, so the presiding officer is lieutenant governor, and I'm not a lawyer, but it had the powers of a full court. And so during that time, I issued over 250 subpoenas, I believe. There were 30 motions filed or more, and then the answers to the motions. There were executive orders to put out. So I began reading, and probably over the summer, more than 1,000 pages of history, documents, motions, you name it. And then my son was a criminal court judge, so he helped put me through a boot camp and gave me a couple of the pointers of how to be a good judge. And then before we knew it, it was September 5th.
You're not a lawyer, as you said. There are some lawyers in the House.
Yes.
Representative John Smithy from Amarillo, Travis Clardy, master trial lawyer from Nacogdoches, who were opposed to this impeachment, even Harold Dutton, a lawyer here in Houston. Did their statements impact your thinking? How did you approach what they had given you?
So I decided not to go back and look what the House did during the summer, mainly because what I knew I didn't think was the right thing. They had testimony under oath. It was hearsay upon hearsay. They had investigators to report what they had heard. There was no time for members to really vote on it. So I thought, and at that point I had already read a lot of what happened in 1917, and we had talked about it with the Rules Committee. I already knew that in 1917 they did it totally differently. They had, and this is what Smithy and Clardy and Dutton talked about, of the 2 statewide impeachments in the House, in the past, they took testimony under oath. There was cross-examination. They allowed the defendant to come in and make their case. They gave ample time to the members on the floor to study all of that before making a recommendation for impeachment to come to the Senate. And in 1917, there were boxes and boxes and boxes that came over as real evidence. This time, there was nothing. And what John Smithy said, he said, what the House is doing this time is indefensible. Travis Clardy said, what we're doing here is something that years from now, another House will look back and say, we don't know what we're going to do in this impeachment, but we're sure not going to do that. And then Smithy also said that the House was taking an approach of hang them now and judge them later. So I didn't pay too much attention to the House, except I knew the history and what they were doing. But I was just focused on getting ready. And the truth was, as I told this, I met with the senators the first day of the trial, and I'd put a firewall up between myself and the senators for most of the summer. I didn't want to talk about it at all with them. We had a gag order, so we couldn't talk about it with each other. But I told them 2 things. I said, whatever you do in the trial, however you vote, unlike I hear in the House, there were lots of arms twisted by leadership to vote for impeachment. You know, it's like a loyalty vote for the speaker if you don't vote. I said, this has nothing to do with session. This doesn't impact bills that you'll file or committees that you're on or chairmanships. This is what you need to do. The second thing, when you go out there, everything you've been texted, everything you've been emailed on, everything you've read in the paper, everything you've heard, everything you've been told by people back home, all out the window. The only thing that counts is the evidence that's presented in this trial. That's what you judge the Attorney General on. And then they went out.
You know, I said at the beginning that this became must-see TV across the state of Texas, and of course one of the most compelling items in this story was Attorney General Paxton's former mistress, Laura Olson.
Yes.
And how was it determined? She did not testify. I know people were waiting for her to testify. She did not. How did that happen?
Well, my son, who had been a criminal court attorney, said, Dad, the best judge is one who doesn't talk too much but listens. Let the parties have their say, whether it's on the floor or if you're at the bench discussing an issue. And when they talk over each other in court, just say the court reporters can't do their work, so settle down. And so I tried to follow that model. And I was a good listener, and I am a good listener during session, but I'm a good listener to everything they presented. So when that came up, they both came to the bench. The Paxton side said, well, she's going to take the fifth, so why bring her up? And the House side said, well, we want to bring her up and ask her some questions. So I said, let's go to the back. We took a break and we went back to the office. I call the Alamo room. You've been there many times. You know that room. And we sat around the table and I listened to first Laura Olson's lawyer, and she said, look, she's going to take the fifth on everything except say her name. She may be involved in another trial. We don't think it's appropriate to put her in this position. And so they filed a motion to quash, in other words, not allow her to testify. I then listened to what the House said. Aaron Epley, who I thought was one of the better attorneys for the House side, I thought she did a fine job. She spoke, and then the Paxton team spoke. And I was leaning towards, but I hadn't made up my mind what to do. I was thinking, well, I asked the House, I said, so you're going to ask her 20 questions and she's going to take the fifth on each one? What's the point? And then the Paxton team said, and we can't cross-exam, so it's unfair to us. It became clear to me, Sherry, that neither side really wanted her up there because they didn't know how the jury would respond. The House may have thought she was a good witness, but maybe the jury wouldn't have not liked it. And obviously the Paxton team didn't want it. So I said, as I said throughout every issue we had of disagreement, can't you all work this out? And without missing a beat, Aaron Epley, not Dan Patrick, Aaron Epley said, let's just say she was present but not available. And I looked at, Busby was there, Murr was standing behind him. I said, what do you all think? Busby and Murr nodded immediately. I said, so you two agree that it's present but not available. And then Aaron said to me, well, we have to have something because we don't want to look like we're not calling her to be a witness. So that's how it worked out. I never ruled on the motion. Those were not my words. And it was the two parties, the same two parties, by the way, that agreed on the disagreements on exhibits, that agreed on 24-hour witness rules that you can't call someone unless we've had 24-hour notice. The same two parties, that they agreed on 24 hours would be for direct and cross-examination. So this is how we ran the trial. And in the Senate, I try to always get people to agree before making a decision. Right. And that's how it happened. That's why she didn't take the stand. The two parties agreed based on the House's language.
Every news story that I have read has pointed out that you took over $3 million in campaign contributions from the side of donors who were very much in favor of Paxton being acquitted.
Right.
The question they never asked, the Texas press being the Texas press, is how much did the other side give you?
About $3 million. So the folks watching this may not know, but we're not allowed to take contributions, which I think is the correct thing, during session. We can take contributions for the first time the last 10 days of June. And everybody wants to have a good report for July 15th because that's a report for the rest of the year. And I normally raise maybe a low of 3, a high of 6. It's usually 4 or 5 or 6 million in that 10 days. I mean, Abbott raised 18 million. So I raised 6. I'm the second largest fundraiser in the state. And the pro-Paxton side, I say pro-Paxton, it's clear that that PAC gave me $3 million in cash and a loan. But the other side, and it wasn't TLR as a PAC, I mean, I think they gave me a little bit of money, but it was a lot of the other money came from all the donors, most of them to TLR. And look, some of those people at TLR were supporters of Paxton, but in general it was seen that that money was coming from the other side that maybe would not have been totally pro-Paxton. So of the $6 million, it was $3 million on each side, but no one ever knew that. And here's the deal, Sherry, about money, period. And I look at this with all members. People think, well, they're influenced, by someone who gives them a donation. You don't last long in this business if you do this. It's so apparent if you're doing that. I've raised, I think, 60-some million over my time in lieutenant governor because it's expensive to run statewide. I spend, 15, 20, 25, 30 million a race, and for primaries and runoffs and generals. And so you're always raising money. It never impacts you. I mean, I really don't know anyone that it impacts. You just move forward, and that's what you do. So that was just a frivolous story written to try to make me look bad before the trial from the people that like to criticize the lieutenant governor.
Governor, we're going to talk now with one of the jurors
in
the Paxton impeachment trial, Senator Brandon Creighton, a Republican from Conroe.
Hi, how are you?
Just great, Brandon. Thank you for being with us today.
It's good. It's good to be with you, Sherry.
Brandon, why did you vote? You started from the beginning and you voted against all the articles of impeachment, all 16. What was your thinking? What did you see when that list was sent over?
Well, Sherry, I voted on summary judgment at the beginning of the trial for many reasons, and I know Representative Smithy's comments from the House floor were mentioned by the Lieutenant Governor. They had a major impact on me. I think they had an incredible impact on many of the jurors. Not to just take those comments at Representative Smithy's word, but to sort of launch and research from there on some of the things that he had mentioned. For instance, prior impeachment efforts in Texas, I think there's been 5 or 6. There's only been one statewide official in 106 years, but those prior impeachment efforts, the House built a record. And in the impeachment process for Governor Ferguson, the House sent over 70 volumes as a record that they had built by bringing in witnesses under oath, allowing the accused to testify and also to refute allegations and to cross-examine those witnesses under oath. Due process was afforded the accused. In every one of those categories for this impeachment process, they were missing. And I just felt like even though I might be on the non-prevailing side and from there I would move forward to consider the evidence for the rest of the trial, it was important to make sure that we did not tell the House that weaponizing impeachment for the future is acceptable.
And you are an attorney, Senator Creighton, right?
Correct. I'm an attorney, and I've also worked for 2 different states' attorneys general, in Texas and in Oklahoma. So I know how the offices work, and at the same time, I'm adept at my own legal analysis, and I spent a lot of time in this very effort.
Was there a pivotal moment for you in the trial? I mean, you didn't like the process, clearly. But as the trial proceeded, was there a pivotal moment for you?
There were many. I've thought quite a bit about what I might say as the most pivotal moment for me, but it really stood out to me when Ryan Vassar testified that the top deputies that did leave all together to go to the FBI and eventually become whistleblowers, it stood out to me that Ryan Vassar testified that when they went to the FBI, they went with no evidence. They went with only his words, a good faith belief of wrongdoing. And the fact that they did not notify Attorney General Paxton that they were going to the FBI, that he testified that they went without evidence, that Ranger Maxwell also testified that he had no intention of pursuing any investigation whatsoever into Nate Paul's concerns that a federal search warrant and affidavit had possibly been tampered with. I just felt like those things really stood out to me as a major surprise and a turning point.
Tell me about when, after the defense rested and Lieutenant Governor Patrick released the jury for deliberation, what was that process like? Were you all, was it like 12 Angry Men? Did you go in a room, or how did that work out?
Well, it was like almost every other experience I had in this entire process. It was historic, and I say that with reservation, not with much excitement. I mean, the Senate chamber was locked down with only the jurors and DPS officers. Binders were placed on the tables where the defense and prosecution counsel were positioned, and those evidence binders, or all the documents related to what both the prosecution and House managers and the defense had agreed to either put in as evidence or to just share together as documentation. Many of the Senate jurors went through all of those binders, searching for their own answers, working towards finding the truth on their own. I was very impressed with my colleagues and how much time they put into that. Overall, it was almost 8 hours of work after both sides had rested their case.
Senator, on behalf of the people of Texas, I want to thank you and the other members of the jury for all the work that you put in, and thank you for joining us today.
Well, I appreciate the opportunity, and thank you for what you're doing to help get the facts out these absurd innuendo rumors that calls were placed to influence jurors, or certain political organizations had an effect on the jurors' minds, or that political donations had anything in the world to do with the jurors making certain decisions. Every individual juror took this job and role very seriously. And I think all of those allegations and rumor mill are just absurd. So thank you for helping get the facts out, Sherry.
Thank you.
Yeah, you know, Sherry, and those, you know, the new conspiracy that some try to spin, and some from the House, because they want to deflect the blame now, the blame from doing a very poor job of what they did, breaking precedent from the past, and impeaching without any record. The senators, I want you to compare this, spent 90 days preparing for the trial, reading and studying what they could in history. They spent 9 days in the courtroom, somewhere in the neighborhood of 60 hours of testimony. And they spent between 5 to 9 hours, depending on who they were, individually going through the exhibits one more time and their notes. One of the senators took 170 pages of notes. And to suggest that anyone would influence their votes, I mean, I put a firewall up between them. I didn't talk to them pretty much for the whole summer, and surely not during the trial. But if there was any arm wringing, and if there was any poor work done, it was in the other chamber. I'm just saying that to be the truth. If you think about what I just told you, 90 days, 9 days of trial, 8 or 9 hours of deliberations individually, compared to a 4-hour committee hearing and a 4-hour debate on the floor. Which side did what the founders expected? The Senate did.
Let's talk to another juror in the trial, State Senator Pete Flores, a Republican from Pleasanton.
Well, howdy, everyone.
Hey, Pete.
Hey, Senator Flores. Very anxious to talk to you about this. You are one of the 2 members of the Senate with a law enforcement background. You're also not a lawyer. And in the beginning of the trial, you voted to hear all the articles of impeachment, not to dismiss any of them. How did you make that decision?
Well, to me, it was a pretty easy decision in that, you know, if someone would accuse me of something I would want to hear the case. So the House felt it necessary in their mind to present this to us for judgment. And so I felt that we needed to hear it. You know, you're never going to put it to bed unless you heard it. That's the way I was feeling as well. And so this way would put it to bed and set it aside one way or another, and to prove their case beyond a reasonable doubt before the people of Texas and us in the Senate.
So as a law enforcement officer, was there a pivotal moment for you? Was there a red flag as the trial began, as you went through that 60 hours of testimony?
Well, you know, in my experience, both in the agency world and also in dealing in law enforcement and having testified in court, you know, from JP all the way to federal court, you know, I kind of knew my way around things, and so it was actually a number of issues of testimony and dealing with a number of witnesses, especially when they were cross-examined and could not present the facts beyond a reasonable doubt, rather a lot of ifs, maybes, coulda, mighta, instead of, you know, show it to me, show me the kill shot. Now, I don't want to see a shotgun shot. I want a kill shot, and that wasn't there.
Senator Flores, tell me about your process of deliberation when Lieutenant Governor Patrick dismissed you and the other jurors. What did you do? Who did you talk with? What did you want to look at again?
Well, you know, during the rulemaking process, we were very deliberate to make sure that we ensured the integrity of the process in terms that the information was provided and that you know, that we could discuss with each other on certain issues, perhaps issues of law, but to ensure that decision was ours individually to make. You know, contrary to a regular jury where they arrive at a consensus to be guilty or not guilty. In this particular case of impeachment, it's each of ours individual decisions to make. So sometimes you would get clarification. You know, you could ask, well, you know, what is that statute, or what do you think the Constitution said on this? But my general process in this historic event was to, you know, I resorted to my notes, some notes that were taken during testimony, other things that I remember, you know, that where questions were asked, you know, can you produce this? Can you prove that? My process was pretty straightforward. You know, again, you made an allegation, prove it, and that standard of proof wasn't met.
So in wrapping up, you are a inveterate campaigner. You're out. You talk. You know your communities very, very well. What kind of feedback have you heard since the trial was over?
Well, so far, of course, there's a lot of folks, you know, in the general public that, you know, really didn't know there was a trial going on. I mean, but those that were involved in the party and involved in the process of politics, generally speaking, were supportive of the vote. And the reason was that I think this case, this court of impeachment, as opposed to the ones previous dating back 100 years, they had the benefit of live stream. They could hear, they had the benefit, you know, of being informed. They could read what our rules were and what the allegations were. So very transparent, and they could listen to every bit of testimony that we were hearing. So, and kind of arrive at the same conclusion, generally speaking.
Well, thank you so much, Senator Flores, for your service to the state of Texas and for your great work on this impeachment trial and letting us see behind the scenes from your perspective.
Well, thank you, Sherry, and Senator Governor Patrick for his leadership in this very difficult task and for allowing me to serve on the Rules Committee.
Thank you, Senator. You know, Sherry, he said something very early on when you said to him, you know, you wanted to hear the evidence, and he said, yes, because if I were accused, I'd want to get this behind me and be very clear. And a lot of people asked me and made the point during the summer, why don't you just send it back to the House, the people who were very pro-Paxton? And the answer was, the way the Constitution is written, we have to receive it. And we believed that we had to have the trial. But even if someone would argue the point that we could have sent it back, that would have accomplished nothing. Because Ken Paxton, different, you know, when Bill Clinton and Donald Trump were impeached, they didn't have to step down from office and they didn't lose a paycheck. As soon as they impeached, Paxton was out of office, suspended, with no paycheck. That's why John Smithy said, we're hanging them and judging them later. That's what he said on the House floor, the longtime trial lawyer in the House. And so had we sent it back, let's just say we could have, and we did, they could have said, well, we're going to take another year to investigate this if you didn't like this case. So they could have kept Paxton out of office without a paycheck pretty much for the rest of his term. So we had to take it on. And just in these first two jurors that you've talked to, Senator Creighton and Senator Flores, I have fine people of high integrity in the Senate. And I respect every one, the Democrats, the Republicans, some who voted for conviction, some who didn't. You know, every Democrat but one actually voted acquittal on one of the articles. They did their job seriously, and they put in the time, they put in the hours, they put in the work. And had the House done the same thing and take witnesses under oath and cross-examination, all of that, I don't think they would have ever sent impeachment to us.
I think that's really true. It was made for TV watching. Yeah. You got rave reviews everywhere that I heard, pronouncing overrules and sustaining, just doing a great job as judge. Let's hear from one more of the jurors that was at the trial, Texas State Senator Paul Bettencourt from Houston.
Thanks for letting me on.
Hey, Senator.
Hey, Senator Bettencourt. I want to start with you in a different spot. So the day after the Senate voted to acquit Ken Paxton, the Wall Street Journal, which is the closest thing that we conservatives have to a national newspaper, came out and excoriated the Texas Senate for making the decision that they made. What was your response to that?
Well, my response was, quite frankly, revulsion, because it was propaganda. I really was very disappointed. The Texas Senate had spent a lot of time doing research, hundreds of days, 700, maybe 1,000 member days just leading up to the trial. And it was preposterous propaganda, what I read in the Wall Street Journal. And one of the comments they made about Lieutenant Governor Patrick was just a bold-faced lie. It was somehow that he had called members during deliberation and had flipped them. And there's just nothing further from the truth. It's just completely untrue. And it really, quite frankly, got my Irish Catholic side going because I was fuming about it because it was so far from the truth, it was pathetic.
It's very hard to tell what's going on in Austin if you're sitting in New York. And that was a very big example. So you just believe whoever called you, the one or two people on the phone who gave you a briefing. So you're absolutely right. They really missed the boat there. Tell me this. What was your deliberation process? You voted to dismiss all the articles of impeachment from the beginning. What was your thinking there? How did your process change or evolve in the trial to the final vote, or did it?
Well, first off, the House process of impeachment was just atrocious by any standard of measurement I understand. You didn't have witnesses that were sworn in. There was no cross-examination. You had investigators talking to witnesses, talking to House members who then proceeded to a vote. Oh, and they gave out 4 only pages of documentation to House members. Then they have to vote on them. It was horrible. I mean, it can't be repeated again. That's why I support Lieutenant Governor Patrick's call to change the laws, because even Nancy Pelosi's House, when they impeached President Trump, they swore in witnesses and allowed cross-examination, but not in the Texas House, and it can never happen again. So that's why I voted initially to side with on the pre-trial motions of basically dismissing these charges. There's also a debate about in the Texas Constitution and the laws about whether an officer can be impeached for items that have happened prior to an election. And all those are in my journal entry now and as part of the record of the trial.
So you represent the largest county in Texas, Harris County, and I'm sure a few people, the whole state wasn't under a gag order, although maybe there was some myth that they were. So I'm sure that a lot of people reached out to you on both sides. What do you think about the political jeopardy for people who voted in this trial going forward? What are we looking at 2024?
It's very important to understand. The jurors looked at the evidence, and the evidence had to be at a standard of beyond a reasonable doubt. The jurors did not believe that standard was met. And if you're going to go to the public and say we're impeaching and removing somebody from the office of Attorney General or whatever statewide office, you have to have a silver bullet. You have to say, here's the problem, and you have to be able to explain it to the public. Well, when the defense rested and there was an audible gasp in the courtroom, I knew at that point in time that the defense had not gotten to beyond a reasonable doubt, and they had made their case. And the public knows it too. And the reaction that I'm getting in the field is literally 99+% right decision, glad you all voted that way. Because if you had listened to the trial, and I'll leave you with this, Sherry, I have one friend of ours who runs a radio program. He's blind now. He listened to 100% of the trial, and he said the people that voted for acquittal were 100% right. He listened to every nuance because the Board of Managers of the House, they had to make that claim beyond a reasonable doubt. And they simply didn't get anywhere close because 16 senators were the minimum against impeachment, and you actually had to have 21 senators for.
Senator Betancourt, thank you so much for joining us today, for your service to the people of Texas and your service on this trial.
Thank you all.
Thank you. And I know he meant to say when the offense rested, when the House managers rested, surprised everyone.
Right.
And when Rusty Hardin said, "Oh, I rested too soon. Can I have a mulligan?" And I said, "I'm sorry, no mulligans here in the court." You know, you talked about these decisions, and I have to give credit to Lana Myers, who was a former prosecutor, criminal court judge in Dallas, and on the 5th Court of Appeals, who was my legal counsel sitting next to me. I'd never met her. God sent her to me, and she was just the right person. And I had originally thought I would share the gavel with whomever was my legal counsel, because it was to hire a retired judge in the rules. And the first day, I wasn't comfortable, Sherry. The very first day after Jeff Mateer was the witness, and the next was going to be a cross-examination by Tony Busby. So it was the first time. And so I kind of struggled through that first day with Jeff on direct. And we took a break, and I said, "Judge, I'd like for you to take the gavel on this cross because, I'm not sure I'm ready for it. And she said, "You're the presiding officer, you're doing fine, and I'm there to help you when you need help." That lady had no ego. A lot of judges would have grabbed that gavel for this historic trial out of my hand and never given it back. So Lola Fender, Chris Sterner, Darrell Davila, my legal team behind me, they really helped me. Probably 70% of the calls I made on my own, because my son taught me. Look, I've been in the legislature for 17 years. I've heard thousands of bills debated. I'm a really good listener. I know what germaneness is. I can hear what an argument is. So in this case, I just had to learn hearsay. It's not too hard. Learn leading the witness, not too hard. Speculation, not too hard. And the complicated ones, we would turn around and discuss. And sometimes, let's just say the judge and I had our own communication system when I was a little stumped. And someone said, "Well, Dan missed a few." Of course I missed a few. Of course I missed a few. So does every umpire, so does every judge. But both sides, I believe, at the end of the day, felt it was a fair trial and they had been treated fairly. They thanked me for listening to them at the bench, and I know it was fair because both sides were unhappy at different times with me.
Tell me, Lieutenant Governor, how you pulled this off. I mean, we've listened to 3 of our state senators. Every state senator they are among the highest ranking officials in the state.
Yes.
They represent almost 1 million Texans.
Yes.
They are a no-nonsense group of people, Republicans or Democrats, as you said. You are viewed by many. I've worked for you for many years. I believe you're the leader of the conservative movement in the country. You're a big, big presence. The members of the House who brought it over have been leadership in the House. Tony Busby, maybe one of the most famous lawyers in Texas.
Yes.
How, with all that firepower in one room, were you able to hold it together with no explosions, no fights breaking out, no one was caned? How were you able to pull that together?
God has given me great peace and calm in my later life. If I were 30 years younger, maybe not. Mm-hmm. Again, I've presided over now 5 sessions as lieutenant governor. And this was very similar in some ways to doing that. And I'm usually pretty calm on the floor. I'm a little bit more casual than I was in the court on the floor in session. The second thing is, Sherry, the week before we did a walkthrough, one day with the senators and then one day with the lawyers. And I said to DeGuerin and Hardin and Cogdale and Busby, I said, the 4 of you are some of the wealthiest, most successful, famous lawyers in the history of Texas and the United States. But 50 or 100 years from now, no one's going to remember any athlete or any movie star or any big case that you settled. They're not going to know anything about you except what you do in this trial. This is the one that will be in the history books. And so our first goal is to have a fair trial. The second goal is to keep the integrity of the Senate intact. This is history. And I was expecting maybe a circus, a lot of high-profile personalities. They were very respectful of the process. They were very respectful of me. They treated me like a real judge. They didn't always agree, but they were very respectful. I thought both sides presented their case well, and I think they seized the moment. So the truth is, they helped me run a smooth trial because they really did, I think, act in a professional, responsible way.
One thing that you did that was not typical for a trial judge
Yes.
was after the vote was taken,
Yes.
and the senators had voted to acquit overwhelmingly. It wasn't a close vote. You issued a statement. What made you decide to do that?
Going into this trial, Sherry, I can't speak for the senators, but I think this would be fair to say that they thought what I did. There would likely be a conviction. The House could not have sent us over 16 articles and not had the silver bullet, as Senator Flores said, at some point, beyond a reasonable doubt on at least one article. So even the night of, and when I sent them out to deliberations, I took my legal team, we went to see Oppenheimer, a 3-hour movie, because I knew they weren't going to come back shortly, and at least overnight I thought, or the next day, or later in the night. And then we went to dinner, and I thought that night, maybe there was a conviction on 1 or 2. I didn't know. I mean, that they really were playing poker face. Now, maybe some of the members, the jurors, talked with each other in the deliberations. Well, what are you thinking about this? But there was no jury poll. There was no vote. No one knew the vote until they came on the floor, even themselves, the total vote. And so I prepared a statement for conviction and acquittal. And
Like you do on election night.
like I do on election night, exactly. And I thought he might be acquitted based on everything they said. I didn't think the House proved their case, but again, they're the jury, I'm not. And the statements were basically the same. It was just a little different on the front end. But some people may view this, and probably maybe some House members are watching this now, thinking that this is an attack on the House. It's not on individuals. It's an attack on the process. Because in the future, whether you're a Republican, a Democrat, or an independent, no one should be impeached based on hearsay. They deserve due process. They deserve testimony given under oath by people. They deserve to be able to cross-examine, as Senator Creighton, I believe, said, all the boxes, the volumes of records that came over in the other impeachment trials. And this time there were 4 pages. This process was indefensible. Those were the words of John Smithy. This process was something people will look back on and say, we don't want to do it like that. Those were the words of trial lawyer and Representative Travis Clardy. And so this interview that we're doing, and the other interviews I've done, 50 and 100 years from now, or 150 for the next impeachment, no one's going to go back and look at this interview or read a newspaper clipping. So I felt it was important to get it in the record of what we did that we thought was right, like time, a factor, keeping it condensed, giving both sides plenty of time, et cetera, and some other good things. But I knew the House wasn't going to put it in the record. So I had to establish the record, because I don't think, and maybe some people now for the first time, until this was over and I said what I said, I don't think most people knew that the House took no one under oath, no cross-examination, had no record, had no witnesses, had no fact base, just hearsay. And that cannot happen again. And so that's why I said it. And if some people were upset by it, so be it. It's important for history to know what happened and how we got to where we got. And so it's not personal. This is important. Overturning someone who's been duly elected statewide by millions of people should be a very high threshold. And no House in the future should base on what someone said, that someone said, that someone said, and then present that to 150 members and say, well, someone said, so let's impeach him or her.
Impeachment is a very jarring event. And
Yes.
you think in our lifetime we lived through the Clinton impeachment?
Yes.
Trump has been impeached.
Yes.
Regardless of what you feel, we're now beginning impeachment proceedings for Joe
Yes.
Biden. And as you say, this is jarring for us, regardless of where you are, because it's saying we're going to overthrow the election.
Yeah.
But you've recommended changes in the Texas
Yes.
Constitution.
A couple of things. Number one, in the federal trials, I think I said this earlier in the program, Clinton and Trump didn't have to step down. They weren't assumed guilty and had to prove themselves innocent. But in Texas, when you're impeached, Paxton was out immediately. And like I said, had we just thrown it back to them, they could have sat on it for another year or two and he would have still been out of work. So we need to change that in the Constitution, that if you're impeached, you continue to serve until you're proven guilty and then you step out of office. Number two, we must make it a shall. The House shall put any witnesses under oath who want to bring charges, shall give due process, shall have cross-examination, shall give 150 members weeks to study the evidence before they make a vote. That should be in the Constitution as well. And there are some other issues that we'll look at, but today impeachment has become like a parking ticket. Oh, we'll just impeach this person. We'll just impeach that person. And that's not the way we're going to have democracy. Again, in Texas, no matter what you think about any evidence you heard, maybe people watching think, well, they should have convicted, or maybe they thought the acquittal was right, or somewhere in between. That's not the point. It has to be a fair process and a due process for anyone who's accused of it wasn't even a crime they accused him of. It was just something he did that he should be removed from office. And we just can't do it this way again. I hope the House will join us in making these changes to the Constitution. Once again, it's not a partisan issue. It's just a real life issue.
So before we close,
Yeah.
Texas trial of the century, a historic event. How does it go down in history? What are your grandchildren going to say when they read about their grandfather being the trial judge here?
I hope they say, for the benefit of future generations and legislators and voters, that the House process should not be duplicated, that the Senate process could always be better. Our rules weren't perfect. I sure wasn't perfect. But the Senate put in the work. We put in the 90 days, the 9 days of trial, the hours in deliberations, the pages and pages of notes taken, the thousands of pages read, that the Senate did it right. And I believe we did it right. And again, I respect the vote of every senator, Republican, Democrat. Republicans voted for conviction or acquittal. In their mind, I believe they followed their oath, and that was to follow the law and the evidence. And one thing I'll close with, it was so important that we do not bring out the Sam Houston Bible very often. I've had the privilege of being elected 3 times and taking my oath of office on Inauguration Day on the Sam Houston Bible. And I did it, you know, when they swore me in, when Nathan Heck swore me in. And the night before, I called someone and said, "What do you think if you all put your hand on the Bible?" And they said, "I think that would be great." And so it took a little time, but every member, when they put their hand on the Sam Houston Bible and took that oath, I believe it took it to a new dimension. And I hope Texas looks back and realizes the Senate really did their work. Whether people agree or disagree, we did the job that the founders would expect us to do.
Thank you so much,
Thank you.
Lieutenant Governor Patrick, for
Sure.
giving us a look behind the scenes of the historic Paxton impeachment trial.
Thank you.
Thank you so much for joining us.